Okay, I've just asked my son for recording. Okay, I'm recording.
Yes, you are recording.
Okay, okay. Now we start with Epsilon English. You continue with Epsilon English. Uh, so many important website for English law, for law in English, like Unilix, uh, Unidra, CASG, ICC, UNCITRO, or Europa, and many other separate uh, website for specific law, like US law, like French law, or like English law. The law.Cornell refers to United States law. Laissez France refer to French law, and lawteacher.net refer to English law.
Thầy
Uh,
ơi, thầy share screen lại được không ạ? Thầy chưa share screen.
okay, can you see? Can you see the screen?
Yes, I can.
Okay. Okay. So we have many important website for the law in English and for the Vietnamese law. For the Vietnamese law, uh, the na.gov.vn refer to the website of the National Assembly. The National Assembly. egov.gov.vn refer to the website of the government, the Vietnamese government. mog.gov.vn refer to Ministry of Justice of Vietnam. It's the official website. And we have many other important websites to study business law. In Vietnamese, we have thông tin pháp luật dân sự. In Vietnamese, vietnameonline.com.vn is referred to commentary on law. It's draft of the law. And we have many documents, drafting documents of the business law. The website sotaitamphán.gov.vn refer to the cases, the transparency cases within be published by the Vietnamese court. So let me repeat. We have many websites in English. I only list some important websites to study. And the Vietnamese website. You should keep in mind that it's only some important website to study. You can find more. You can find more. Okay. I will send my handout presentation for Miss Thumb to send you. Okay. Now let's overview to the law. Maybe you will remember about it. So the first important is type of law. The type of law. The second, maybe you remember, it is sources of law. Sources of law. The area of law. The area of law refers to some specific area of the law. And it's in my topics, business law. So it covers the type of law, sources of law, and area of law first. And after that, we will complete for the business law. Okay, now we start with type of law. It may be popular to you. Maybe you remember for type of laws. The first is very important. It defines the difference between the substantive law and procedural law. The substantive law and procedural law. If substantive law refers to the content of the law, refer to the right obligation, the law will be defined the right obligation of the party involved. But procedural law refer to procedure. They define the procedure in which you owe the obligation to follow. We have many kinds of procedure: criminal procedure, civil procedure, administrative procedure, labor procedure, and maybe more. The second type of law is public law and private law. Public law refers to a kind of law in which at least one party is state or state authority. The private law refers to the law may focus on governing individual, mostly for individual. Like civil law. The example for public law like constitutional law, administrative law. The constitutional law refers to the most important aspect of the state and the law. It's a fundamental right obligation of the citizen. But the private law refers to the right obligation of the citizen. It's very normal activity of the citizen, like contract, like agreement. If you agree to sign contract, if you agree to put article into the contract, it may be referred to private law. The next distinction between the type of law is civil and criminal. If the civil refers to a very normal activity set by the citizen or individual for the civil activity, like I mentioned before, maybe contract, maybe agreement, maybe transaction. But criminal is very serious activity. It's serious activity carried by person or organization. If the individual or organization carry the activity, but this one is violated for the criminal code or criminal law, it may be prosecuted. If this one is a very serious activity. The next category refers to municipal and international law. Municipal and international law. The municipal law refers to domestic law, like Vietnamese law, like Chinese law, American law, French law, for example. It only focuses for within the country. If you sign a contract in Vietnam, for example, the Vietnamese law applies. It refers to the municipal law. But international refers to something like the treaty between at least two countries. Between at least two countries. It may be referred more. If of the country, it refers to the treaty. It is very important sources of international law. Okay. So if you have any question, during my presentation, ask me.
Can you talk about international law again, because your mic got cut out?
The international can be divided into public international law and private international law. The public international refers to the relationship between the country. They can agree to treaty to cover something like passport, visa, maybe agreement between the party concerning the boundary between two countries, the interior water or something like that. It refers to the most important issue between two countries. But the private activity, the private international law refers to, it may be something refer to the conflicts of law. How can you choose the law apply? The law in this case refer to domestic law or refer to the system. The system. For example, if you sign contract, you sign international contract, you should define the governing law. For example, in the contract between French and the Vietnamese enterprise, maybe you agree to apply French law or Vietnamese law or even third law. So this one refers to private international law. The private international law refer to which the most important refer to conflicts of law. The conflicts of law. How you can decide the law apply. Okay. So the international refer to both public international law and private international law. So the most important for substantive law, and you see on the screen, it refers to legal rights and duties or obligation. But procedural law refer to the rules or procedure. The rules or procedure for enforcing the right. For enforcing the rights mean in the case of something wrong happen, something violation happen. Suppose that the breach of the contract happen. Okay, you can bring the lawsuits into the court against other. In this case, the court applies rules for enforcing the right. The public law refers to the right and power of the government. So it means that the government should be seated to discuss right or power between the country. It may be two or more countries agree to right power, and they must accept it by saying that I agree to share user right obligation. I agree to reduce my right and power in some way. For example, maybe they accepted for the foreigner to enter into Vietnam. maybe we can set the legal barriers to prevent the enter, or we accept the enter. If we agree to other country to accept the enter, okay, it refers to the public law. So in order to accept the enter, we agree the treaty with other country to accept the enter, accept the foreigner to enter. But if the public law refers to the government right and power, the government right power, the private law refers to individual and legal entity. The most important is individual. So the relation between the individual or among individual are very important and belong to private law. And the most important example for this one is how can you sign the contract? How can you set the contract? Okay, the municipal law. Maybe you can say that is national or domestic or even internal law. This refers to sovereignty. It's referred to sovereignty. The sovereign state refers to state has the full power to decide any activity, power, or rights within the state. In the case of the foreigner want to enter into the territory, the sovereignty state can accept. The sovereign state can accept or not for the foreigner to enter or even to leave the country. They have the full power to deal with. You should give by that they have the full power to deal with. Okay. So the type of law is very important to imagine how the law govern, how the law operate is very important. We have the law to govern the legal rights. We have the law to govern the rules, decide the rules to apply. We also have the law for the government. It is authority state power. Or the law only govern for the individual. And we have the national law or international law. If the domestic law refers to law within the state, the international refers to ship between at least two countries or two nations, at least two nations. It may be based on the most important document in the treaty. The treaty is very important to decide the relationship between the country, between the nation. Okay. And the sources of law. Why we should remember the sources of law? For the business law, it is the law to govern the business activity. That's why we should understand the legal documents, to regulate the business activity. The most important to govern for the business activity is constitution. The constitution, because the constitution sets the most important right and obligation as the party involved. It may refer to the citizen. They set many important issues for the business activity, like property, like ownership, and the fundamental right obligation. Because you must have the property, you have ownership, you have the right obligation, and any other rights should be based on the constitution. The next is very important in the civil law, I mean for the private law. The civil law is very important for the business law because the civil code, for example, is the most important to decide the right obligation of the citizen and individual. The civil code refers to the right obligation, refer to the contract, refer to organization, refer to the ownership, refer to transaction, refer to property. And that's why under the sense civil code is very important to understand the law for the governing of the business activity. Okay. The next is very important is administrative law. Administrative law. Administrative law is very important because if you want to carry business activity, you should register. Maybe the state asks you or requests you for registering. If you want to open a company, you must register. Okay. Register for the company means you give your name, your place, your article, your charter. You send it to the state to accept. And after accept by the state, you are company or you have company. So that's why it's very important to imagine administrative aspect of the law in terms of the business activity. Maybe the law requires you to follow some binding rules in terms of the state authority. And it depends to the country. For Vietnam, for example, it refers to commercial law. For the French, it refers to the commercial code. So the civil code and the commercial code are the very important law for the business activity. If the civil code refer to general rules for the right obligation, for the contract, for the transaction, for the property, for ownership, the commercial code refer to specific issues, only specific issues for the commercial activity. So they will decide what does it mean for the commercial. When the activity becomes a commercial activity, they set the criteria to decide and also decided on the types of the commercial activity, Do you know trade in service? The trade in service refer to is very specific contract for the services like transportation, insurance. If you sign for the service contract, you do one job and receive a fee. It differs from the sale of good contract. The sale of good contract is a kind of contract in which the contract complete if you complete transfer the ownership. The transfer ownership or title is very important to decide the contract completed. It differ from the service contract. The service contract refer to the job and the fee. So that's why the law concerning the service contract will define how can you decide it, agree the article for the service contract, how can you pay the fee, how can you decide the fee. So that's why the sources of law is very important, not only for the business law, it's also important for any other law. But in terms of the business law, you should remember for Constitution, Civil Code, Commercial Code, or Commercial Law, and maybe some state authority regulation. You register for the company, for example. Okay, do you have any question? Any question for the type of law or the sources of law in terms of the business activity? Can you follow my presentation? Okay, can you hear me? Can you follow the presentation? Any question? Any question?
No.
Do you have any question?
No.
Okay. So in terms of the sources of law, you should understand and remember the Constitution, the Civil Code, the State Authority Regulation, and the Commercial Law. And the Commercial Law. Maybe you can find more. But the most important, refer to Constitution, Civil Code, State Authority Regulation, and the Commercial Law. Okay? And I want to list some area of law, and many of them refer to the business law. Many of them refer to the business law. The administrative law is not business law, but some aspect of administrative law concerning to the business law. It apply to state regulation. For example, the ban for the goods, the ban for services, the requirement for the contract, requirement for the company, requirement for organization, requirement for the charter, and requirement for bring a lawsuit into a court arbitration. Okay, in some way, it may refer to administrative law or any other state regulation. Antitrust law. Antitrust law. The antitrust law refers to the law concerning maybe unfair competition. Of course, under the antitrust law, you can find more. But one of the most important example for antitrust law is unfair competition. Unfair competition. Or maybe you can find competition law. This law apply for competition activity. Or the contract law. It's the law governing the contract. How can you sign the contract? How can you agree the right obligation of the contract? How can you transfer ownership? How can you send property under the contract? The next is corporation. The corporation. The corporation law refers to the law for registering, operating, and termination of the company or corporation. The next maybe, but not always involved. It is intellectual property law or IP law. IP law, in fact, is not business law, but maybe very important to decide in some way. For example, if you work for the company, you are employee. In the case of the employer request you to do something, maybe they ask you to make some kind of invention. In this case, you are employee. You work for employer in the enterprise and make the invention. If you make the invention, IP law apply. And in this case, we have at least Three law apply. Three law apply. We have the employment law or labor law. We have the enterprise law, and we have the IP law apply. And maybe other. For example, if you see the tax law, in fact, it maybe not refer to the business activity, but maybe. For example, in the case of queries business activity, you owe the obligation to pay the tax for the state. The tax law may be related to the business law. Or you can find more example for the area of law in terms of the business activity. For example, in the case of you sign the contract with the foreigner, it may be referred to nationality law, or even refer to private international law, because you must decide the law apply or the choice of law. So the area of law is very important to imagine the overview of the business activity and the law governing the business activity. Or alternative dispute resolution, or ADR. The ownership dispute resolution refers to how can you deal with the dispute by alternative methods like mediation, like conciliation, by doing the dispute for alternative dispute resolution. You must agree. For example, you agree to put into the contract the article for dealing with dispute by alternative dispute resolution, by mediation, for example. So you must agree. You may agree in by the contract or agree by separate agreement for alternative dispute resolution. So imagine the list of the area of law. It's very important to imagine where the business law is, how the business law related to other areas of law. How can we imagine the business law? And how can you define the name of separate area of law and business law? You can find many examples. There's a name for the aspect, various aspects of business law. Also dispute resolution, administrative aspect of the state regulation, competition law, or even construction law. Some aspect of the labor law. How can you pay? How can you pay the salary? How can you decide the right obligation of the employer in terms of the enterprise? Property law, or tax law. Of course, we have many other aspects maybe not related to the business law. For example, the state law. The state law is very separate from the business law, maybe. Health law, gaming law, maybe, or immigration law, maybe not related to the business activity. As I mentioned before, when we studied before, we have many legal systems. And the legal system set the mechanism for what? For creating, for interpreting, and for enforcing. Creating, interpreting, and enforcing. Enforcing what? Enforcing the law. Where in a given jurisdiction, for example, the Vietnamese legal system is a mechanism for creating, for interpreting, for enforcing the Vietnamese law in the Vietnamese territory. It's based on the Vietnamese jurisdiction. And as you remember, we have three major legal systems in the world today: common law, civil law, and Islamic law. I don't want to repeat it more, but you should remember we have many systems from a mechanism for creating, interpreting, enforcing the law. Okay. Now, let's look to many aspects of business law. If you look at the screen, okay, you can see the business law. So we have many aspects of business for domestic activity, for business law, and many aspects of business activity for business law in terms of international or foreign. For example, if we sign the contract with the foreigner, if we open account into a foreign bank, okay, all of them refer to business activity, international business activity, and we have many kinds of them. You can find many examples for international business and domestic business. But at first, we can divide it into the domestic business activity and international business activity. And even domestic or international, the business law refers to the contract. The most important institution for the business law is contract, business organization, dispute settlement, antitrust law, and IP. Of course, you can find more, but we have at least the most important contract, business organization, dispute settlement, antitrust law, and IP. We have contract for domestic, it means domestic contract, domestic organization, domestic dispute settlement, domestic antitrust law, and domestic IP. And we have the international contract, international organization. You know TNC or MNC, multinational corporation, or transnational corporation is referred to international business in terms of business organization, or dispute settlement. In the case of the dispute happen, you can refer to the foreign arbitration to deal with dispute. In this case, the foreign arbitration have the full authority to deal with. This one refer to international dispute settlement. Maybe you can refer to ICC arbitration to deal with this dispute. This one is international. And you can define many issues concerning to international and domestic law in terms of business activity. For international, you can find treaty, customary law, and remember, it's decision of the international organization. For example, in terms of EU, for example, we have directive, we have the decision, for example, is a decision for international organization. Soft law. In terms of law, maybe you can divide it into the hard law and soft law. The hard law refers to the law over you follow. You also obligation to follow. It's step by step. But soft law, it may be the law agreed by the party or by the community. For example, For example, maybe leak mercantoria in some way, maybe refer to shop law, or PICC, for example, refer to the shop law. The state contract is contract between or among the country or state nation. It's very important to agree between two nations, and it will be governed and binding the state. And observe, even international law or domestic law it will be governed by business norms. Even you follow international or follow domestic law, it refers to business norms. Why? Because the business activity must follow the business norms. The business norm is very important to govern the various aspect of business law. Trade usage. The trade usage is very important to decide in the case of we like the binding agreement, the binding authority rules to govern the contract. Maybe you can refer to trade usage, or state authority refer to trade usage to deal with this too. The standard form contract is very important. For example, in some kind of international or domestic business activity, maybe the association. Do you know association? It is a professional organization for professional career. The association may be set standard by contract to govern the specific contract like transportation, like insurance, like textile, coal, for example. It's a very specific contract and under standard rules. And you can find more business norms like uniform law insurance instruments or general principle, as I mentioned before. So let me repeat. The business law refer to both domestic and international. So it can maybe related to domestic activity or international activity. For domestic contract or international contract, for domestic organization or TNC, for domestic dispute settlement or international dispute settlement. And we have many norms to govern. We have business norms, we have international norms, we have domestic norms, or we have other business norms to govern to the business activity. So if you want to understand the sources of law, is not only refer to Constitution, Civil Code, state authority regulation, or commercial law. It also to imagine many instruments, the domestic instrument or international instrument, and other business norms to govern the business activity. So that's why imagine to the business activity or the business contract, for example, you should imagine what kind of business rules apply. So we want to fully understand for the business aspect in terms of business activity rules. You must understand the international rules, domestic rules, and other business norms for the contract. So that's why maybe you have the first question in terms of the sources of business law. It may be very important question, but difficult question. How can you decide the law for business activity? How you can make the choice of law? The choice of law. And in fact, in some way, it may be refers to, in terms of the to the make the choice of law for the contract, it may be referred to the forum, the kind of the article under the contract refer to how can they decide that the law apply, right? And how can they decide that the mechanism to deal with the dispute. So it may be referred to the court, like the Vietnamese court, to deal with dispute. Okay. Any question? Any question? Any question?
No.
No. Okay. Why have no question? Okay. Okay, if you have no question, we will continue. So you must define, it may be most important, what is business law. So the business law refer to the rules and regulation. The rules in this case refer to maybe constitution, civil code, the commercial law, and the regulation refer to state or administrative rules. It may be come from the government and govern the conduct of business. It refers to the separate kind of activity, maybe carried by organization, maybe carried by individual, or even by state, So decided the conduct of the activity, the type of the act of the activity. It's very important to understand how you can carry the activity and how the business law can be governed. So understand the rules and regulation and understand how they can govern. It's very important to understand how the business law can be operated. So you must understand the rule of and regulation as business law. Try mention all of them. Try mention all of them. The rules and the regulation. And all of them will be covered for the business activity. The business activity. For domestic activity, you apply domestic law. For international activity, you apply international, domestic, and business norms. The business norms is very important, maybe more important for the international activity than domestic activity. Maybe we can define the reasons why this one is maybe better used for international law rather than for the domestic law. You try to define it in detail later. But at first, you should imagine that the rules and regulation, okay, refer to many things: international, domestic, and the business norms. Business norms. The most international refer to the treaty. The treaty. In the case of we have no treaty, or we have lack article of the treaty, you maybe apply domestic law or customary law or other. For example, if you remember, maybe I refer to CISC, the International Convention for the Sale of Good Contract. It's the Vienna Convention, 1980. This one refers to, this one says that the country maybe agree, or accept to exclude the article of CISC or even CISC to apply. It means that they maybe don't apply CISC if they don't want. So in the case of the CISC don't apply, they maybe apply domestic law. Or in the case of CISC is not enough to cover, or enough to cover. Why? Because the treaty is agreement between or among countries. That's why they only agree for something. Agree for setting contract, agree for the formation, agree for termination. But many things they cannot agree. For example, transfer ownerships, transfer the title, how can they deal with dispute, how about arbitration, how about the court, for example, how about state regulation. They cannot agree. And in this case, domestic law apply. So we have applied both domestic law and international law for the business activity. And in some way, it may be for business norms, if any. Okay. Any question? Do you have any question?
Can you back to the slide 12?
What kind of slide?
Slide 12.
12. This one?
Yeah. Can you talk more about soft law?
Okay. The soft law. Okay. We have hard law and soft law. The hard law, soft laws may be not official division, but maybe they can refer to hard law, soft law. The hard law refers to, for example, domestic law, like civil code. For example, is hard law. Why? Because the civil code decided by the state, the individual agree they owe the obligation to follow. They owe the obligation to follow, even they don't want. Okay, this is state obligation. State obligation, even they don't want to follow, they owe the obligation to follow. Okay, but in order to follow the soft law, they agree, or they or state or association set the way follow the soft law. It means that the soft law is not a way to follow. They only follow the soft law if they agree, or if the association or the state or all of them or the community is a way to follow.
Is that the same with the contract?
The soft law is not a contract. The soft law okay, now we should distinguish between the contract and soft law. The contract at first is agreement. Contract is agreement. Contract is agreement. Why is it agreement? Because the contract may be settled between the party. They agree for the right obligation, and after they agree, they own the obligation to follow. So this one may be referred to private party. The soft law also refer to agree. Okay, but agree by other subject like association. Or professional organization. Or other, or even community. And all of them, after they agree to set a soft law, they set the way to follow. And after they set the way to follow, the community, the commercial community, for example, set the way to follow. And after they set the way to follow, any person, any organization, as a member of association or belong to association, organization, or belong to the commercial community, owe the obligation to follow. So if the hard law refer to state, the hard law refer to state, okay, the soft law refer to other subject. If the hard law refer to state obligation, if you not follow, they set the sanction to punish you. But for the soft law, maybe because association is not powerful like state, and that's why the sanction is not powerful to apply. It may be affected to the company because the association may be very important for the company if they are the member, or they want to represent or set reputation for the community, for the commercial community. And that's why the soft law is very important. If they want to keep reputation, but the hard law is law. In fact, the hard law is state obligation. And if you not follow the state obligation, you owe or suffer the sanction. For example, penalty, for example. Okay. So the hard law you always follow by the state. Soft law, it depends. If the community agree to apply, it becomes a law. But you should keep in mind that soft law refer to the commercial, mostly refer to commercial activity. But the hard law refer to anything: administrative, civil, criminal, employment. But mostly for the soft law refer to the commercial activity. And maybe the soft law maybe can use in terms of arbitration, maybe. Arbitration may be applied hard law and soft law, because arbitration is not the court. The court refers to sovereignty. Okay.
Okay.
And that's why the court only follow and must follow the state law. For example, the Vietnamese court must follow the Vietnamese law, but the arbitration may be follow other, depends to the agreement between the party. They can apply the French law, Vietnamese law, or the third law. It depends, or any other rules, even the soft law. Okay.
Okay, thank you.
So, understand business law or any aspect of the business activity, you should refer to both international, as the most important treaty, and domestic law. For domestic law, we have Constitution, Civil Code, maybe state authority or state rules, and the commercial law, for example. And in some way, I say that in some way, it depends. Maybe the association, maybe a community. It depends to the professional activity or professional association. Maybe you follow the cheat usage, standard form contract, uniform law, or general principle. What is general principle we mentioned before in terms of the civil law presentation? We discussed for the general principle before. So you can find the information for the general principle and the previous presentation. Okay. Okay, now I think we have a short break. And the question before we have a short break. Any question? Do you have any question for website, the type of law, the sources of law, the areas of law, the list area of law? Any question?
Teacher, can you send us this file and we can note while learning?
We will send you via Miss Thumb, and Miss Thumb will send you.
You just
Because I
start
have
this file.
no, I no have your email, so that I send to.
You just need to upload this file on the file of this room.
On the rooms.
Yeah.
For you. Wow.
For all of us.
I'm not expert on this one.
Okay.
Let me see. Maybe I ask my son.
Okay.
How can I send? How can I send it? Wow. Okay, let me ask my son to send it. Okay.
Yeah.
Any more question?
No.
Okay, if I have no question, I think that we have a short break, maybe 10 minutes. Okay.
Yeah.
Okay. Thank you. Okay, I've just sent my presentation. Please download it. Okay, thanks. Okay. Okay, can we start? Can we continue?
Yes.
Yes.
Teacher, can you
Yeah.
can you explain to me again on slide 13?
13, this one.
Yeah. When do we need to refer to these laws? When do we need to refer to these?
Business norms.
Like every no, like everything, like international law, domestic law, business norms. When do we need to refer to them?
Okay. 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 Now let's look to slide. Domestic law or international business norms only refer to that what kind of contract involved. What kind of contract involved? In the case of the contract signed within the territory, within the country, only domestic law apply. For example, in the case of the Vietnamese citizen, sign a contract with the Vietnam citizen in Vietnam, only domestic law apply. And in this case, both public law and private law will be applied to govern the business activity. For example, we remember that we have many kind of institution for the business activity. For the contract, for example, if you want to sign contract, I mean for the formation of the contract, you can agree to the article of the contract. It belongs to your will. Okay, you have to decide what kind of article you follow by agreeing to the party. Both parties can agree to the article. So in terms of the agreeing of the article to apply to the contract, refer to private law. The private law apply. You have full power to agree. Okay, but the law set some requirements. For example, in the case of you want to sign contract, but you're not full competent, or you not fully understand to the nature of the contract. For example, it is 6 years old, 17 years old. Okay, maybe in this case, not fully understand the nature of the contract, and the law set some requirements to follow. The requirement set by the law maybe refer to public law. Or you want to open company, okay? The law accepts you the right to open the company. It's a private law. You have the right to open company. And the law decided your right to open the company is a private law. But if you want to open a company, you must register. And the law set the requirement for registering. So in this case, it's referred to public law. The law defines the rights. It refers to private law. But the law requires you to follow for registration. It's a public law. It's a public law. The law accepts you the right to sign contract, but the law require you to notary. The law require you, if you sign a specific type of contract, you must register. This one is the public law. So both public law and private law apply to deal with dispute. Both public law and private law apply to for signing contract, for opening the company. Okay.
Okay. Thank you.
If the contract signing only in domestic activity, only refer to domestic activity, the Vietnamese citizen with the Vietnamese citizen in Vietnamese territory, only domestic law apply. But in other case, for example, in the case of the Vietnamese enterprise agree and want to sign a contract with the U.S. enterprise. So in this case, you must decide which law apply, So this law may be referred to domestic law or international, or both of them, or even business norms, maybe. For example, if we agree that the US law apply to cover your contract, in this case, the US law is domestic law. Okay.
Okay.
Let me repeat. In the case of the Vietnamese enterprise agrees with US enterprise, you agree US law apply. The US law is domestic law. But in the case of Vietnam and US, in fact, is member. They are the member of CISG. They are the member of CISG. Okay. In this case, CISG means a treaty applied to the contract between the Vietnam enterprise and US enterprise. So they apply CISG first. Okay. In the case of CISG is not enough to cover, they apply the domestic law if they agree. For example, they said that apart from the CISG, they apply US or Vietnamese law or third law to apply. In this case, domestic law apply. Or both of them want to exclude CISG. In this case, CISG not apply because they exclude their CISG. So if we don't want to apply CISG, they said that I don't want to apply. So in this case, you can choose another sources of law, maybe domestic law, maybe other international sources of law, or maybe other like business norms. It depends. It depends to the win of the party. They can agree to apply domestic law, international, or treaty, or business norms, or all of them. All of them. For example, they can set that we agree to apply CISG. In the case of CISG, is not enough to cover. We agree to apply French law. Okay. Or we can, and in the case of the French law is not fully to cover. We agree to set and follow the PICC, the Principal Commercial International Commercial Contract. So the PICC refers to business norms. The US law refers to domestic law, but the CISG refers to the treaty. So under one contract, we can agree domestic, international, or business norms. Or you can only refer to domestic, or only refer to treaty like CISG, or even only refer to business norms. It depends to your choice. But in the case of you bring it to the court, or arbitration. Okay, this is the problem. If you want to bring it to the court or arbitration, because the court arbitration define the also obligation to define the law apply. Okay, so in this case, if you bring to the Vietnamese court, the Vietnamese court apply the Vietnamese law, it's domestic law, not refer to the treaty, maybe, or not refer to the foreign law. In the case of this one is a commercial contract and international commercial contract, the Vietnamese court may be referred to the treaty like CISG because Vietnam is member. Okay. If Vietnam is not member of any treaty, they only apply the Vietnamese law. The Vietnamese court only apply the Vietnamese law if Vietnam is not member of the treaty. Okay. But if you bring it to arbitration, okay, the arbitration tribunal may be referred to domestic or refer to international or refer to business norms, depends to the win of the party. If the party want to refer to domestic and international and business norms, the arbitration accept and follow. Why? Because the national court, like Vietnamese court, only refer to sovereignty. Do you remember this one? In the case of it dealt with by the domestic law, the sovereignty is very important. Because of sovereignty, for example, the Vietnamese court only apply the Vietnamese law, not foreign law. The arbitration is different. Okay. I try to define more detail on what is arbitration, what is court. Is the next presentation. But now we try to remember that the sovereignty is very important, and the foreign court only apply the foreign law. The Vietnamese court only applies the Vietnamese law. Okay, keep remember.
Okay.
Business norms. It's very difficult to explain you right now. But the business norms, in fact, is not the hard law. The treaty or domestic law is hard law. The business norm is soft law. This one is soft law. The soft laws mean it is not a state obligation. It may be set by a association, by community, by organization. It's the last organization, for example, or professional organization, for example. And the party, and many parties accept to follow. They accept to follow. They become the uses of the community, of the commercial community, and they accept to follow. It business norms. Standard form contract, style contract is example. The association, the steel association, or coal association, or textile association. Okay, set the standard contract for textile agreement. You can follow or not. Okay, you can follow or not. If you accept to follow, they recommend you to follow. You can follow or not. If you accept to follow, okay, it becomes a standard form contract. This one is very helpful because it's a very detailed article. It is suitable to the various type of the goods like textile or coal or steel. It is separate kind of contract suitable for the contract, suitable for the goods, suitable for services. Okay. So this one refer to business norms. The business norm, in fact, is not treaty, not domestic law, it's not state obligation. Okay. Now we back to this one. As I mentioned, the business law may be referred domestic and international and we have many institutions. The main constitution is contract, business organization, dispute settlement, antitrust law or competition, and IP, intellectual property. Okay, this is the main institution. Okay, but you can find more. You can find more. If you want to study the business law, at least you should imagine constitution, okay, state regulation, what kind of serious action. You know, smuggling, okay, it's referred to business activity, but it's criminal. Okay, you should understand the contract law, employment law. In terms of the maritime activity, the shipping law. The shipping law is the most important aspect of the maritime law. IP, business organization. We have many kind of organization for the business activity. The law on real estate or the law on property. Law on property. Or even environmental law. This one is maybe not related, but may be related. It depends. For example, maybe one company maybe carries business activity, but they make it harmful to environments. Okay, they make it pollution to environments. In this case, environmental law apply. So the environmental law may be referred to administrative law or maybe criminal. In terms of you apply the sanction, like criminal sanction or administrative sanction, to punish any kind of activity which is harmful to the environment, or service activity. And one of them is insurance activity. The insurance law is very important to understand, or you can find more. The next services is financial. And in terms of financial services, you must understand the financial institution, like the bank, like the credit institution. It's very important to understand. But there's a type of the bank, type of credit institution, and maybe more. And taxation, as I mentioned before, the taxation, or you can find more, many things. And in the case of all of them, Gary, that the dispute happen, it refers to dispute settlement methods like ADR, like arbitration, like litigation. Okay, so many things to study, but the most important is contract, organization, settlement, and antitrust law. And in short, we have three main pillars: contract, business organization, and dispute settlement. Okay, the three most important: contract, business organization, and dispute settlement. So in terms of this presentation, I focus on the contract, business organization, and dispute settlement. Maybe not refer more. But if you want to fully understand or better understand on what is business law or what is legal environment in business, you should study all of them. Okay, it's a legal environment in business. Legal environment in business. Okay. Any question? Or if you are expert of law, you are a law expert. Okay, maybe you can study for the emerging aspect of the business law. What is the new information for the business law? What is happening? How about the future? Okay, it's the emerging aspect of business law. For example, do you know this word? Digital. Okay. What is impact of industry 4.4, 4.0 for the environmental business activity? How can you imagine what happened? How about the aspect of the future? What is the impact of this one? Okay. For example, the digital is one issue of emerging aspect of business law. But this is only for the expert of the law, not for you. Okay. And for better understanding, not only within my presentation, for better understanding, you should study the constitution, administrative laws, criminal, with some aspect related to the business activity, contract law, employment law, shipping law, or even maritime law. Okay, like the shipbuilding contract, the shipbuilding contract, for example, IP, business organization, real estate, environmental law, insurance law, financial institution, law on services, many kind of services, law on services, taxation, and maybe more. And the last, but very important, dispute settlement methods. Dispute settlement methods. Okay. Okay. Any question?
Okay.
So that's why the business law, as I mentioned, refer to the rules and regulation. The rules maybe refer to the National Assembly, for example. The regulation refer to the government. Both rules and regulation with regard for the business activity. Okay, and in some way, maybe you refer to the case. And in Vietnam, in recently, we apply case law. The Vietnamese court accept to apply case law. So it means that we not only refer to legislation, we also refer to we not only refer to legislation, we not only for statutory only for statutory law. We also refer to the case law. Legislation or statutory law refer to the written law. The written law, you remember. The case law refer to the unwritten law. Okay. So, study for business law is not only for legislation or statutory law. It also refers to case law. Okay, it's set by the court for a specific case. If the court decided this one is a typical case, they decided this one become to the case law. The law decided each of the decision of the court become to the case law. Okay. So the domestic law refer to public and private law. It not only refer to statutory law, not only refer to legislation, it also refer to case law. Okay. And they govern the conduct of the business. All these things conduct a business. So what kind of conduct a business? Many things, and I mentioned insurance, financial, transportation, okay, contract, property, ownership, organization, individual, right obligation, charter, dispute resolution methods, environmental pollution, penalty, or many things like that. Okay, it will carry to the activity, but it's harmful. Okay, it may be punished by the law. In this case, refer to criminal sanction or administrative sanction or any other. Or they maybe bring the lawsuit. Okay, they start a lawsuit to the court, or they go to arbitration. So we have many kinds of the conduct of business activity, and will be covered by the rules and regulation. Okay. Okay, now we move to the second lecture. The second lecture is the corporation. Maybe you can say corporation, or you can say company. It depends. You call corporation or company depends to the legal system. Some legal system accept both corporation and company. Some legal system accept only company. It depends. Okay. In these lectures, I choose corporation. Okay. The corporation is a kind of a company when we carry and follow to the incorporated procedure. Incorporated procedure. It is a kind of procedure to open a company or open the corporation. And it's referred to incorporated procedure. But you should keep in mind that the corporation is not only the business organization. We have many kinds of business organization. And the corporation is one of them. The corporation is one of them. In this lecture, we focus on corporation or company. But in fact, we have many kinds of them. Okay? Why? Because we have only 15 hours to study. 15 hours to study. That's why we have enough time to cover anything. That's why I focus on corporation. But in fact, and maybe more, okay, it is the forms of business association or business activity, business association or business organization. The first, I want to say that it depends on legal system. So the name of or the form of business association, it depends on legal system. Okay. Some country accept only one word is a partnership. Partnership. Okay. Some country accept the partnership and limited partnership, but some country accept all of them. You have many forms of partnership. Partnership, limited LLP partnership, uh, limited partnership, for example. We have many kinds of them. So the first is proprietorship. Proprietorship. The proprietorship is a kind of the business association in which only one individual is owner. Only one individual is owner. Even this one is organization, but they have only one person, only one individual, and he or she is owner of this one. He or she is a person registered for this one. He or she is person owes the full obligation for this one. He or she is a person owes the obligation to pay the tax, to transfer property, and to pay the debt of the enterprise. In this case, I choose the business association or business organization. You should distinguish between okay, you should distinguish between the business organization with business entity with corporation. We have many kinds of business organization or entity. For example, proprietorship in this case refers to business organization, but they are not corporation. Okay, proprietorship is not corporation. It is they separate from the corporation. They are business organization, but not corporation. Or joint venture. Joint venture. Joint venture is joint venture in many countries. Joint venture is not company. It's not corporation, not partnership, not proprietorship. It's different. But in Vietnam, for example, the joint venture refers to the company. It depends. Okay, so the form of business association depends on the legal system, or even the name of the business association depends on the legal system. So we have many kinds of business association or organization: proprietorship, partnership, joint venture, corporation, or company, or many other. They are business organization. Okay, but in this presentation, I only focus on corporation or company because we have not enough time to cover all of them. Okay, slowly. But I try to distinguish them. I try to distinguish them in some minutes. Okay, now we have partnership, we have company, and you have corporation. The corporation may be referred to joint stock company. Do you know joint stock company? It's a company based on the stock. They sell stock to the security market. The limited liability company or NNC is not corporation. It's not joint stock company. It's different. But in some countries like Australia, New Zealand, Singapore, or US, they refer to corporation. The corporation. In many other countries, like Vietnam, for example, they refer to joint stock company because we have at least two kinds of the legal system for the corporation. The first one of the legal system refer to the company, like limited liability company and joint stock company. The second refer to limited liability company or NNC and corporation. So the difference is the difference between a corporation and joint stock company. Okay, it depends on the legal system. Okay, now let me back to the form of business association. We have many forms of business association, and in this case, we choose partnership. Okay, limited liability company and corporation to distinguish. Apart from that, we have many things, but we only choose partnership, NNC, and corporation to distinguish. Okay. If you understand zero partnership, it's easier to understand partnership. If you understand limited liability company, it's easier to understand limited. And after you understand limited liability company, it is easier to understand zero partnership. Okay, and that's why we choose partnership, NNC, and corporation. Okay, to distinguish. Do you have any question? Do you have any question for the name of business association? Any question for the name of business association?
No question.
No question.
Okay. Okay, now let's look on the screen on choosing a business association. How can you decide if you want to establish the business association? Try to imagine what is the benefit, what is the harmful. Okay, for example, in order to understand each kind of business association, we try to imagine some aspect of this one. For example, how can you transfer in terms of the capital, for example? It's easy to transfer or difficult to transfer. Okay, in terms of the liability, in the case of the debt happen, in the case of sign the contract, but the contract broken down. So in this case, you also obligation to pay the tax, to pay the money, or you owe the your debt, for example. In this case, you must decide the liability. The next is the control. In the case of you are the member, you are the owner. Okay, how about your rights? How can you control the company? How can you control the partnership? It's very important to understand who control, how many controls, how much share power between the member. The continuity, the continuity refers to how long the company can operate it and cooperate. How long? Is it duration or non-duration? It's very important. Okay, and taxation. You must pay the tax, or company pay the tax, or the owner pays the tax. Okay, some kind of business association, the company pay the tax, but some kind of business association, the owner of business association is the person pay the tax, and that's why you should distinguish them. Okay, for example, in terms of the partnership, the general partnership. Okay, the general partnership. The person have liability is partner. The partner. Okay, and the partner have unlimited liability. Unlimited liability. What does it mean? The unlimited liability means in the case of the contract wrong, the business activity go to very bad situation. Okay, you must pay the debt. If the company, in terms of the company, for example, you only pay the limited debt because in terms of limited liability company, the member only suffer limited liability. For example, they invest 1 billion Vietnamese dong to the company. In the case of the wrong happen, they only lose 1 billion. Okay, they invest 1 billion, they lose. Okay, no more than 1 billion. It's a limited liability. But in the case of partner, okay, they invest 1 billion. The liability of the partner is not only limited to the 1 billion. They must pay by all property. For example, all of the property of the family is 10 billions. They invest 1 billion. Okay, they have total 10 billions, and the debt is 10 billions. They must pay all the debt is 10 billions. It's unlimited. They must pay by the debts, the property, and the family property. So that's why we said it's unlimited. It's unlimited. All the property. But limited means it is only property they invest to the company. Only property they invest to the company. That's why it's limited. Okay, 1 billion invest, 1 billion pay. Okay. The next is should be remember and should be imagined is how can you control for zero partnership, all partner, but you have limited partner. Okay, maybe three, and they have very close relationship. In terms of the limited partnership, we have both general partner and limited partner, but this one controlled only by general partner, only by general partner. For NNC, limited liability company, it be controlled by member. So for the NNC, we have member. For the partnership, we have partner. But how about the corporation? Simple. It is shareholder. Shareholder. Okay. So the person concerned for the partnership is partner. The person concerned for limited liability company is member, and the person for corporation is a shareholder. A shareholder. Okay. For general partnership, For example, it's very easy to dissolve. In the case of the partner death, in the case of the partner die, this one is not continue, it's broken. But in the case of the member die, the shareholder die, it's not maybe not affected to the company. It still continue. Even the member die, even the shareholder die, it still continue. But in the case of the partner die, okay, the partnership die. Can you imagine? Okay, and that's why you should imagine the reason why we choose the form of business association. You have many forms and have many reasons to choose. You must understand the strong aspect and the weak aspect of each business association. The strong aspect for the partnership, the strong aspect for the company, and the weak aspect for the company. Before you choose a business association, should remember and try imagine what is strong and bad a situation will happen. Okay. So we have made a reason to choose for the transfer reality. It's easy to transfer or not. How about the liability, unlimited or limited? How can it controlled by partner or by member or by shareholder? How can it get unity? What happens if the member die? Okay, and taxation. Who pay the tax? Who pay the tax? Okay, the partnership paid by the partner, the NNC by the member, and for the corporation by the shareholder. It's very important to distinguish them. Because this one refer to liability. Who owes the limited liability and who owes the unlimited liability is very important. Okay, so you should imagine why you chose the business activity. Okay, why? What is the reason to choose? What happened? Okay, what is the good aspect of this one? What the bad aspect of this one? Okay, and more important, how can you transform from the partnership to limited partnership to NNC and to corporation? How can you transform? Maybe it's not set the criteria and condition to transform. Maybe not. Okay, it depends the legal system. It depends legal system. Okay, now we went to the form of business association. Okay, we have many forms of business association. As I mentioned, if we try to separate, we can do like that. Okay, this thing refers to partnership. This thing refers to NNC. Okay. In order to become the proprietorship, you need one person. You need one person. This person is ready to pay the tax, ready to pay the full debt by the old property they have. Okay, it's the first form of business association. The second is we have many forms of partnership, depends the legal system. In some legal system, we have many kind of partnership, zero partnership, limited liability partnership, and limited liability limited partnership, or even in Germany, for example, we have silent partnership in Germany. Okay, in Germany, we have silent partnership. It depends. So as I mentioned, I said that it depends to legal system. It depends to legal system. Okay. So I try to list the main article, the main forms of business association, rather than to discuss any of them. Okay, we're not enough time. Okay, we're not enough materials to cover. So that's why I try to choose the main forms of business association. So the most important I mentioned is sole proprietorship. The general and other kind of partnership, the NNC and the corporation. The difference between the NNC and corporation also depends on the legal system. We have two kinds of legal system, at least refers to difference between the NNC and corporation. The first refer to NNC and joint stock company, and the second refer to NNC and the corporation. In the corporation, Vietnam, for example, refer to a joint stock company. US, for example, refer to the corporation. And the procedure for the opening company differ for joint stock company and the corporation. In the corporation, it depends the legal system. Okay. Any question? Any question? Okay. Okay. In this presentation, okay, we only cover for, and I mentioned partnership, NNC, and corporation. Partnership, NNC, and corporation. Okay. And after you understand the main article for what is the partnership, what is the NNC, what is the corporation, we spend a lecture for the Vietnamese enterprise law. Okay, the Vietnamese enterprise law, the most important, refer to the Law Enterprise 2014. And the reason here is we recently applied is Law Enterprise to 2019. Okay. Okay. Now we start with general partnership or partnership. In Vietnamese hợp danh. In Vietnamese hợp danh. General partnership. Okay. What is a partnership? We try to decide what is main feature of the partnership. The main feature. Okay. Now, if you look to the slide, we can see is core owner. The core owner. Equal right. Okay. And share. Okay. Okay, now what does it mean? Okay, for the partnership, in fact, in this case, zero partnership, because you have many forms of partnership. For zero partnership, okay, we have two or more person. In this case, two or more partner, okay, agree to carry business activity. For what? For profit. But the important is they are co-owner. Okay, we have not only one owner, we have co-owner. What does it mean for the co-owner? The co-owner means in the case of the debt happen, okay, owe the partner. Okay, will pay for the debt, will carry the full liability. All of them must pay the debt for the company, for the partnership. And because they are co-owner, they have the right to represent the partnership. They have the equal right. Okay, the partner has the equal right. The partner has the right to represent for the partnership. Okay, the partner has the equal right to manage and share profit. What does it mean for manage? The manage have various meaning, but the most important is they have the right to carry the business activity on behalf of the partnership. They can represent the partnership to sign the contract. Okay, they can represent the partnership to make the transaction on behalf of the partnership, and of course they share profit. They share profit. They have full liability. They share manage the partnership and they share profit. They share profit. The next important issues is who can become the partner of the partnership. The answer is many persons. They are individual, partnership, corporation, joint venture, business trust, estate trust, okay, and any other. So the person is not only referred to individual, it also refers to the other legal entity or other organization. For example, the corporation is a legal entity, okay, and we have partnership is example of it's not legal entity. The no legal entity, remember between the natural person is person created by God, and legal person is the person created by law. Okay, so the corporation is a legal entity, but the partnership is not legal entity. The partnership separate from the corporation. So we have many person can become the partner. So the partner may be referred to individual or refer to other entity. Okay, they are legal entity or non-legal entity. It depends. So we have many kinds of person. So keep in mind that the person is not only referred to individual. It refer more. Okay. And the next is very important. Very important. The partnership is association. What that means for the association? Okay, the association means it's a link between the member, between the partner. Okay, it's closely relationship between the partner. Okay, they agree to accept to manage company. They agree to become the co-owner. They agree to share the profit. They agree, accept that they have the equal right to manage the partnership, and all of them involved. All of them carry as a owner. All of them has equal right to manage, and all of them carry the full liability. But partnership, and that partnership is association. You should keep in mind that the partnership is association, not legal entity. Not legal entity. It's association. Okay, it's closely relation between them. Okay. Any question? Any question about the partnership? Any question about the partnership?
Have any question about partnership?
Oh, sorry, I can hear you. Sorry, I can hear you.
I don't have any question about the partnership.
Okay. Okay.
Okay.
Okay. If you have no question, okay, try to remember. As co-owner, equal right, association. Okay, I underline them. Co-owner, equal right, and association. So keep in mind that the partnership is not legal entity. Okay, they are association. Okay. Now look at this one. I try to explain why this one is association, not legal entity. In terms of it is pays a debt, it is unlimited liability or limited liability. Okay, now look at this one. Okay. Okay, now if you look at the partnership, we have two separate kind of characteristic or feature. The first is the partnership distinct from partner. But the partner involved into the activity the partnership involved. Why? Now we back to the first presentation. Now look at this one. They are co-owner. They have equal right to manage and share profit and is association. So because the partnership is association, and that's why the partnership, it will said that it is distinct from the partner, but in fact, in some way, it's not distinct from the partner. The partner involved into the activity, the partnership, maybe they not separate from the partnership. They not separate from the partnership in terms of the liability, in terms of the managing of the partnership, in terms of the sharing the activity of the partnership. The partner, in fact, agree the agreement to share profit, managing right, and decided how they can associate to the partnership. And that's why all of them have very close relationship in order to manage the partnership. They distinct, but they are association. Okay, not distinct like corporation. or N and C. Okay. In terms of N and C, the member separate from the company. The shareholder separate from the shareholding from the stock company. Okay. In this case, the partnership is distinct from the partner, but the partnership is association. It means that the distinct from the partner, okay, is a feature but not a way. It's a feature but not a way. Okay, we have carry both feature of the partnership, distinct from the partner, and association of the two or more person. Okay. The next is aggregate. The partnership is aggregate. The legal entity in some way, but aggregate. Or this one is different between the partnership and the corporation and limited liability company. The limited liability company or just a company is always distinct from, but the partnership is not away. In some way, all of them carry the activity on behalf of the partnership. All of the partner and each of the partner, okay, all of the partner and each of the partner can carry the business activity on behalf of the partnership, and that's why in terms of the partnership, the partner considers the agent. Do you know agent? The agent is a person can carry any kind of activity on behalf of the partnership. Is an agent. Okay. Every partner. For example, it means that the partnership has three partners, A, B, and C. All three partners, A, B, and C, can represent for the partnership, can do anything on behalf of the partnership. Okay. And the second refer to aggregate is a partner is unlimited liability. It's unlimited liability. What does it mean? It means that in case a partnership carries activity, signing contract, entering into the transaction, and something wrong happen. Okay, each partner carry unlimited liability for the partnership. It differs from the limited company or corporation. The member was NNC carry limited liability. Okay, only extend to something they invest to the company. The amount of money, amount of property they invest to the company. And that's why for the company it's limited, but for the partnership it's unlimited liability. And because I have many features, some feature is distinguished and distinct from, but some feature refers to difficult to separate between the partner and partnership, and that's why they are both legal entity, but not in fact, and a legal aggregate. Okay, some feature for the legal entity, but some feature for legal aggregate. Okay, but for NNC, for shareholding company, it's always legal entity. Okay, it's always legal entity. But for the partnership, okay, some feature for the legal entity, but some feature for the legal aggregate. They are both. Okay. But the same to the company or corporation. They may be shoe or be shoes, under the name of the partnership. Under the name of the partnership. For example, the partnership have the name like Nam and Associate, okay? In this case, this one refers to the name of the partnership is NAM and Associates, and the partnership use the name is a NAM and Associate to carry any kind of activity or before the God or even because the God. Okay. Okay. And the next is the assets. The assets of the partnership distinct from the individual assets. Okay, as a member, as a partner, distinct from the individual asset, but in fact, the partner suffer unlimited liability. Okay, distinct but unlimited, distinct but unlimited, and that's why it's both legal entity and legal aggregate. Okay, it's very specific feature for general partnership. Very important to remember. Both legal entity and legal aggregate. It's not only for legal entity, not only for legal aggregate, they are both. Okay, so how can they form? How can they establish for the partnership? It depends to the form of the partnership. Depends to the form of the partnership. Okay. When and why? I said it depends on the form of the partnership because we have many forms of the partnership. We have general partnership, we have limited liability partnership, we have limited partnership of even in Germany, for example, silent partnership. So depends on the type of partnership. Okay, you can choose, and the law set the requirement for the formation of partnership depends to life partnership. Okay, now for the general partnership, it based on the partnership agreement. The partnership agreement. What does it mean? In order to agree to form the partnership or by the activity carry before, okay, they prove that we have the agreement or they have the agreement, and they said this guy in this case the partnership in this case the partnership, okay, it means that the law don't require any official requirement. Okay, sorry, 1 minute. Okay, only 1 minute. Okay, we continue. Sorry, 1 minute. Okay, now we look back to the form of the partnership as I mentioned. We have many forms of the partnership. Okay, and that's why the law set the requirement for different types of association and different types of partnership. For general partnership, the law don't set any requirements the official requirement for general partnership. The most important is they have the agreement. The agreement may be based on the agreement, written agreement, or based on the activity. And via activity or through activity, they can decide that this one is agreement. Okay. Look at the activity, look at the action carried by them, and the action carried by them proves that between them have the agreement or contract. Okay, this is refer to partnership agreement. The first one. The second is they carry the test of partnership assistant. Partnership assistant. The test of partnership assistant mean not official agreement, not official requirement to be required to say that it's a partnership or non-partnership. Okay, it's by a partnership assistant. So what kind of feature for the partnership assistant? It's the first association. The test for association. Okay, the test for the conducting a business for profit, and the test for the co-owner. They are the co-owner of the partnership. They conduct all of them, conduct the business for profit, and all of them enter into association to carry to the partnership activity. If all of them to be needed, okay, this one refers to partnership. This is test of assistance of the partnership. So the form of general partnership is not required official requirement. Okay, it only needs a partnership agreement and test a partnership assistant. But for other type of the partnership, the law requires the official requirement. The official requirement. For example, the law may be set the requirement to follow. For example, depends the legal system. Depends the legal system. Okay, the law may be set the requirement under statute, under statutory law. The law sets the requirement for each of the partnership or limited partnership follow. So the official requirement depends to legal system, but the law require. It may be more compared to the general partnership, but maybe less compared to the LLC, limited liability company. Okay, more than this one, but less than to the LLC in terms of the official requirement. Okay, even the law require. Okay, so what kind of requirements the law require for limited partnership? Okay, three feature or three requirements. It is a filing application. Okay, it sends the name and contribution. After you complete three things, okay, we become the limited partnership. But for limited liability company, the law require more. The law require more, many things. Okay, let's look at this one. At first, you need article of organization. The article of organization. Okay. The article of organization or charter depends on the legal system. If you follow the legal system for the common law, it's article of organization. If you follow to the civil law system, it is charter, as I mentioned before. Okay? It's charter. So the article or charter requires a name, requires address, okay, requires a name, address of the agent, requires the name of the owner, and how can you manage the NNC. NNC is the most important information for the company. The name of the company, the name of business, the field of business, the principal address, the address of the agent, the name of the owner, and maybe more. It depends on the legal system. Okay. The business name, the law requires that must have the word is NNC or limited by company at the end or before, maybe at the end, or name of the company. Contribution. The contribution is very important because it must invest the company, like property, service, cash, or something like that. Operating agreement. The operating agreement refers to a kind of contract. It is not specific contract, okay, not detailed contract. It's a basic contract and only set the affair of the company, and the right and duty of member. Right and duty of member. Okay. It's the most important for operating agreement. By setting the right and obligation, the duty of member, okay, it's very important to decide how the limited liability company can operate. So if you compare to the NV, only 3 certificate, name, and contribution. But for limited liability company, we have article, business name, contribution, operating agreement, and each of them have many requirements, many more requirements for every company. Okay, and in more details, the law may be set for the requirement for the name. How can you choose name? Okay, what kind of name is maybe accepted under the law? What kind of name is not accepted? Okay. How can you choose the name? What kind of address may be accepted? Okay. How was the criteria and condition accepted for the agent, for the address, and for the name of the company? And contribution. It's not only for contribution. You can find and maybe face with many things. Contribution may be referred to the cash, refer to property, refer to the services, refer to the job, refer to something, and invest to the company. Invest to the company. You can contribute to the company. That's why the law defines the type of cash, the type of property, how can you deal with the property, how about the time for contribution, how can you deal with the contribution, what happened contribution not happen, okay, and how about the article to deal with this thing happen in more details. In terms of the formation, we have at least 4 things: operating, contribution, business names, and article of organization. Okay, and because this one is more requirements in terms of compared to the NP, and that's why in terms of management, this one is maybe the law maybe require more operating requirements. For example, if in terms of the partnership, it's only refer to the partner, only refer to association, only refer to unlimited liability. This one refer to member manage and manager manage. We have 2 kinds of management. The first form of management refers to the member. The right belong to the member. And the second refer to the manager. What difference between them? The member managed refers to the kind of NNC in which all the member participate. In terms of the manager managed, they elect, okay, under the law, under the rules and regulation. By the law enterprise, for example, the law accepted they can elect for the member represent them, and this member can enter into the meeting and make the vote and carry the voting right, and they become to the manager. This manager will be represent them to carry the business activity on behalf of the company. On behalf of the company. So we have different types or different forms. The management of the company, member manage, okay, or the member involved, or manager manage, okay, they elected the member to become the manager of the company, and manager carries activity on behalf of the company. Okay. So depends, okay, depends to the form of the business association. The law may be set the requirements for the formation, or the transferability, or the liability, for the control, for the continuity, for the taxation, and many other. And it differs from legal system to legal system. Okay, differ from the recent time, past time. It depends. It depends. Okay. The forms of the business association may be referred to more, but it may be said, as I mentioned, refers to how can you transfer, how can you suffer liability, how can you control for the business association, what happened if the wrong happened, and how about the pay taxation. Okay. If the NNC, as I mentioned, if the NNC refers to the kind of the company in which the member is unlimited, is a limited liability. The corporation refer to artificial person, artificial person, and shareholder, artificial person and shareholder. And the law may be distinguished between the member of the NNC and the member of corporation. For the NNC, they are member. For the corporation, they are shareholder. Okay. The law also set the limit for the member, for the amount of member, for the member of the company. The member of the company. It depends on the legal system. It may be 40 or 50 okay, member for the NNC, but maybe more or maybe no limitation for the shareholder. It also means that the corporation is a large company compared to the NNC. Larger company compared to the NNC. The corporation is a kind of the company in which they encourage the person or the member or any other person invest or contribute to the company under the form of the stock. And by the stock, they become the shareholder. Okay. The capital of the company, of the corporation, divided into the equal part called share. Divided into the equal part called share. Okay. The share is very important to decide that this one is a stock company or non-stock company. It's also decided the member of the company is a member or shareholder. Shareholder. Okay. Or the size of the company. It's a large company or very large company. Okay. The NNC may be large company, but the corporation may be very large company. Okay, it's different. And in order to become the corporation, okay, you must adapt some attribute. Or we say that the corporate attribute to become the corporation. Okay, it depends on the legal system. It depends to uh, the law in recent time or the past time. It may be some change. Okay, the most important, as you can see on the screen, legal entity. It must be legal entity. Okay, must be formed, comply to the law. Okay, must carry the limited liability. Okay, it can be transferred share. The share can be transferred. If a pattern existed, okay, if there is something wrong happen, it still continue. Okay, centralized management. What does it mean? It means that the shareholder elect the person represent, and he or she, all of them, represent for the company to carry the day-to-day operation of the company, day-to-day operation of the company, on behalf of the company. Okay, so if you adapt this thing, okay, maybe your company, okay, on the first side, and the company can carry or act or action as a person, but not the same in fact. Of course, you have some difference between the person as individual and corporation. But the corporation may be considered as a person and citizen. It may be considered as a citizen, but for some kind of the feature, it's maybe not in fact. Okay, they are person or citizen. In terms of the law accepted that they can carry the separate activity on behalf of the corporation. Okay. Okay, I think that's enough for today. Do you have any question? Do you have any question?
No.
No.
Any question? Question? Okay. Uh, okay. If you have no question, please come right to the website to find the materials involved. Apart from my presentation, we have many websites. It's very useful website to study. This thing. Okay. This thing concerning to internet organization or international website. This thing refer to domestic website. It's US, French, or England. Okay.
Okay.
It may be helpful for you to understand my very important information. For example, if the question refer to the CISG, except to this one or this one. Okay. If the question refer to Incoterm, refer to international commercial terms. In the case that you want to make the transportation, you must decide that where the risk can be transferred. Okay. The risk can be transferred is on the Incoterm under the ICC WBO. Okay. In case that you want to find the question in terms of the arbitration, for example, uh, and some kind of the very specific services like transportation, like franchising, for example, like factoring, for example. Find it at unsin.org. the international organization under UN. Okay. And for the next presentation, this one, the presentation is Europa.eu. You can find the European Union law. European Union law. Okay. For Vietnamese, if you want to find the law of Vietnam, except to the na.org, it's the website of National Assembly. You can find many documents, information. For eGov, gov.vn. Okay, you can find many information and many useful document. It's a legal document. Okay, for MOG, you can find both the commentary, commentary, practical commentary, the legal documents, and many information for the government. For time, you can find many writings. It's helpful writing. Understand how the Vietnamese legal system operates for the beyond PRB. Okay, you can find the commentary of this law. For this website, you can find the public case law. The public case law of Vietnam. For this, okay. Please practice at home. Okay, for this website, and you invite for the next presentation. Okay, you can find information, use information on this website. Okay. I can get any response.
Okay.
Okay, we can use this thing, okay, to find information and find the case, make it just example, okay. It is same to this, especially for this one, and this one, okay. We can find the case and question, okay, for the exam.
Okay.
Okay. I think it's enough for today. That's all for today. Okay. See you in the next presentation.
Thank you.
Okay. Thank you.
Thank you.
Okay. Enjoy your weekend. Okay.
Thank you. You too.
Được.